A very good morning, friends. Hope you're doing good. So, I'm waiting for a few of you to join my session. So, I'll start with a brief introduction about myself, right? I am Cyril Jacob, your educator at Unacademy. I hold a bachelor's in law from Kerala University, a master's in law from Bristol Law School, England, right? I have years of teaching experience and I'm an independent practicing lawyer. I also hold a diploma in cyber law from Asian School of Cyber Laws, and a master's in business administration. So I'm a management graduate as well, right? So today I'll be teaching you mainly, my classes will be purely in English, right? I'll be highlighting the concept of open government and right to information from an Indian perspective. I will be talking about the evolution of the right to information and open government concept system in India, right? So hope you'll be able to catch up. If any doubts you have, you can kindly comment and I will try my best to clear those doubts, right? So hope my audiovisual is clear because I believe it's okay from my side. It is 100% from my side. So let us start. So what is an open government? When we talk about the concept of open government, we should understand that it is guided by a few principles, okay? A few areas. First is transparency. The concept of transparency refers to being clear, right? When you say in our science classes, we have studied transparency, translucency, opaque, all these concepts. So, what is an opaque object? You cannot see through. What is a translucent? It is semi see through. And what is transparent? It is completely being open and clear as to what the object holds. For example, a glass tumbler, you can say a crystal glass, it will be crystal clear. That's why the concept of, we say, if we understood a topic, is it clear? It's crystal clear. So what is it? You can see through. So those forms of systems, when it is incorporated into a particular government or in a particular system of administration, it is called a transparent system of administration. So it is necessary, when we talk about open government, we should first remember transparent form of administration, right? Second is accountability. Now a government has three branches, right? Even in my previous session I had highlighted it. It is executive, legislature and judiciary, right? So based on this, there is a type of accountability that needs to be maintained. A government has to maintain an accountability. That's why we have the budget, we have the Auditor General of India, because there is some kind of accounts to be maintained. There is some kind of a audit to be kept in the books of records. Third one, participation and collaboration. This is to be read together. Third aspect is participation and collaboration. So a government should actively partake in the society's upliftment or development. If a government fails to partake in the society's upliftment or development, there will be a big gap, there will be a vacuum. So openness in government helps to check on misuse of power or abuse of power. So the reason why a government should be an open government is that it helps to check, right? There's a principle of check and balance. So in this case, it will help to check on the abuse of power or misuse of power by that particular government which is in office, right? So this concept of right to information, openness, seeking information, it has been highlighted in Article 19 of the Universal Declaration of Human Rights. So Universal Declaration of Human Rights, the abbreviation is UDHR. Okay, that particular Article 19 recognizes the right to information, RTI, right to information. So as per this article, let us get into the word to word meaning. Everyone, that is all human beings, everyone has the right to freedom of opinion and expression. Freedom of opinion and expression is contained in Article 19 of the Indian Constitution. And the same Article 19 of UDHR guarantees the right to all the citizens of the world. So India is a signatory to that declaration of Indian Constitution, right? So, dear friends, hope you are following, right? If you have any doubts, please put them through, right? So I'll be commenting based on your responses also. So right of freedom to opine, to express. This particular right includes freedom to hold opinions without interference and to seek, receive and impart information. So a person under this Article 19 of Universal Declaration of Human Rights 1948 provides the right to individuals, okay, to seek, receive and impart information. Not only information, even ideas. So we should consider that also within the purview. Through any media and regardless of frontiers. What is frontiers? Frontiers refers to boundaries. So not keeping any boundaries into mind, every individual in this world has the right to freedom of opinion and expression. And this particular right includes the freedom to hold opinions. You can give your opinions. Your opinions is totally, you have the fundamental right. And no sort of interference from any person whatsoever. That is what this UDHR Article 19, which is passed in 1948, holds. So, whether the Article 19 of the Indian Constitution encompasses or envisages this particular right to information, that we will be knowing or learning in the upcoming slides. So moving on. Now when we look into the evolution of the Right to Information Act, dear friends, or sorry, not act, right to information, you can say legislations or concepts. In Right to Information Act in India came into the year 2005. Okay. However, there are other countries, dear friends, which introduced it. So the country that introduced the concept of open government and right to information was Sweden in the 17th century. So Sweden is a country which is so developed that almost 90% is a cashless economy. They do not rely on cash, they rely on other forms of payment, say digital payments, right? So it was Sweden who brought in the concept, the country which brought in the concept of guaranteeing the citizens with the right to information aspect. It is the first country in the world. Then almost after 2 centuries, almost 2 centuries it took for another country, that was also in Europe, almost 2 centuries, that is almost 200 years, it took for a country to introduce RTI in their respective territory. That is 1951. Finland. Right? Hope you are following, dear friends. So France was the third country in the world to introduce the concept of access to information. Access to administrative documents means access to government data or info. So next country in line, USA. Okay. The foundation of the RTI lay in the constitutional right of free speech. So RTI is engraved in the Constitution itself, American Constitution, in the form of free speech. Now, Canada. Canada enacted the Freedom of Information Act in the year 1986. So fairly recent. Australia and New Zealand enacted the Freedom of Information Act in 1982. So before Canada, the Freedom of Information Act was enacted by Australia and New Zealand, both the countries together simultaneously. South Africa, the Constitution of the Republic of South Africa was established in the year 1996. And since 1996, the Constitution of Republic of South Africa provided RTI as a basic fundamental rights for every citizen in the country. So if you take an evolution, this is like an evolution pattern, evolution hierarchy. From 1766 onwards, RTI has evolved. Alright. Now, India, what is the situation in India? We should know that prior to moving into Indian concept, we should know there are several aspects of open government and RTI. So what are these several aspects? The first aspect is there should be an element of presentation of documents by the government in the court in case of some litigation. What is litigation? When the matter is taken to court, that particular matter is being heard in court, then it will be said as litigation, right? The parties to the dispute or who is bringing the matter to be heard are called the litigants. All right. So official secrecy. Now, there are certain secrets or classified information that will not be shared with the public. Right? Yes, the Article 19 of the UDHR envisages the concept of right to seek, receive and impart information, but there is some information which cannot be shared. Like, because the prime reason of this is because you do not want the secret of weapon making disclosed to the public, or how to, the national security of a country should never be placed in the hands of a common man because it will be a threat. So certain secrets cannot be dealt with in open government. Then access to information. So these are all part and parcel of the open government administration system. Now, this is very important from your syllabus also. So there is something like people's right to know. So people's right to know has two aspects. I've highlighted the first one in the form of questions. So how far the government should use criminal sanction to deter free flow of information? So what is the scope to which a government will introduce a penal action to stop the free flow of information? That is something which has to be considered by the citizens. Second aspect is how far the government is under a positive obligation. Okay, there is an method of being obliged to impart or send information to the public. So, to make the information available to the people, not in the prohibited category. So, what is classified? What is unclassified information? Unclassified information you can give to the public. Okay, they have an access. But classified information is like confidential documents that cannot be shared. Because the confidentiality clause should be maintained. Right? Hope you followed. Dear friends, my classes are only in English, so please bear with me. Even the slides are in the notes you have to take down in English. There is no Hindi in my class, so please adjust. Right? Moving on. Now let us take the evolution of right to information in India. All this is very important from your NTA UGC net syllabus, and I believe most of you are taking the exam next month, right? In the early 90s, there is a big social activist called Aruna Roy. She was in Rajasthan, and the RTI movement, the right to information movement, right? It began in Rajasthan in the 90s. There is a beautiful union called the Mazdoor Kisan Shakti Sangathan. Okay, the worker, the laborers class, they formed a union and they wanted to eliminate certain local corruption and exploitation of farmers. Kisan is farmers. In India, there is a famous slogan, Jai Jawan, Jai Kisan. So, hail soldiers, hail the farmers. Okay, so to avoid the local corruption and exploitation, they formed a union, the workers union, farmers workers unions. Unions called the MKSS, Mazdoor Kisan Shakti Sangathan. So this two movements of Aruna Roy as well as the Mazdoor Kisan Shakti Sangathan resulted in the formation of the RTI movement. It was very rampant. It started taking pace. Right? Now, in the year 2005, the RTI Act was enacted and aims at promoting transparency and accountability in working of every public authority or office. So, if you want to seek certain information, you have to file an RTI application to the Public Information Officer. Normally an RTI application, you can even do e-filing today. You can file it online. However, Post has its own benefits. Okay, it's a 10 rupee application. At least last time I checked it, it was 10 rupees. Right? I have a lawyer. Since I'm a lawyer, I do a lot of RTI applications on behalf. So I have that full file. Unfortunately, I can show you. It is just in my office room, right? But I don't have time to show you that. But I will explain to you. It aims, the applicant has to give his name, his address of communication in all that. He has to fill it and post it, send it through registered post and to the concerned public information officer in his town, city or village. So please remember, only an individual, that is only a person, one individual can use this facility. A group cannot use this facility. I repeat, a group cannot use the facility of filing RTI applications. So if you, my dear friend, want to file an RTI application, you have to do it by yourself and one person only can do. You cannot say you and your friends. You cannot form a team or you cannot be united and come together and say so and so names. In the application, you have scope for only one name. All right. Hope you are following difference. Shall we move on? Now these are the phases or stages of RTI evolution in India again. Stages of RTI, the development stages, okay? It is a process because it's a chain of interlinked activities. Kindly excuse me, let me have some water please. So the first phase or the first stage of development for RTI pertaining to India, since today we are dealing from an Indian perspective. So during the period of 1975 to 1996, that is almost 2 decades plus 1 year, or you can say 21 years in the making to be specific. So in the phase 1, there were demands to public and private authorities for information. Okay, the citizens, the demands were made by citizens who are part of various social groups like NGOs. Social groups can involve NGOs, non-governmental organizations. So there is something called National Campaign for People's Right to Information. Okay, that is the NCPRI, the National Campaign for People's Right to Information. This particular campaign was established in the year 1996. And dear friends, this was a landmark movement. This played a key role, a crucial role all over India since it was established. This played a key role for the Right to Information Act to come into force. After this particular campaign, there were many courts in India, from Supreme Court to lower courts, that supported transparency in the public offices or government offices. So various judicial orders supporting transparency was witnessed during this phase of 1996 onwards especially. Now the second phase is 1996 to 2005. Okay. In this phase, the RTI bill was proposed to the parliament, in the parliament, and the RTI bill got a big boost by the National Campaign for People's Right to Information, which is the NCPRI. The RTI movement witnessed major growth in this period. Okay, various nations enacted transparency laws during this particular time frame. So not only nations, even various states also enacted laws during the time period of 1996 to 2005. So let me reiterate the importance of NCPRI and let me focus on this third phase. Allow me to focus on this third phase also. With that, we will move on. Right? So the third phase provides that from 2005 to present, there is an increasing effort. So it's a constant evolution, okay, to observe the constitutional perspective. So, right to information, whether it should be included in the constitution or how important it is engraved or enlisted in the constitution, was considered from 2005 till today. Today is the, say, 20th November or 21st November, sorry, 2019. Till today, there is a constant effort to observe constitutional perspective pertaining to RTI applications in India. Moreover, there is criticism for every legislation. To address those criticism, to address those there are issues with public information officers, assistant public information officers, who are called the PIOs and the APIOs. So how to address the challenges? It's a constant movement, right, dear friends? Any doubts, please let me know. Moving on, dear friends. Now this is the timeline of RTI in India. This is very important. I'm putting a star highlighting the important. So 1975 till 2005, this is a timeline, right? 30 years in the making. So how did RTI evolve further from scratch? 1975. In the year 1975, the Supreme Court rules that citizens of India excuse me, have a right to know. So once the Supreme Court rules something in favor of the citizens of this magnitude, all the bodies, all the government bodies are obliged to follow. They have to follow the pattern, right? So in 1982, the Supreme Court rules that RTI is a fundamental right. This was a big move. Because if the Supreme Court gives such a big judgment, okay, that RTI is a fundamental right, it's a big boost for all. All right. In the year 1985, NGOs seek access to information because of the environmental hazards related to the Bhopal gas tragedy. Now, Bhopal gas tragedy was the biggest and most major industrial disaster in the world. Till today, there is no industrial disaster of the magnitude of Bhopal gas tragedy. After Bhopal gas tragedy only, the government of India started considering a lot of guideline implementation pertaining to environmental laws. So the Bhopal gas tragedy led to senior activists, social activists and NGOs, non-governmental organizations, to seek certain information relating to the environmental hazards, especially associated with the Bhopal gas tragedy. In fact, the Bhopal gas tragedy led to the formulation of another legislation called the Environmental Protection Act 1986. All right, moving on. In the year 1990, government falls before transparency law. So it agrees that transparency law can be introduced. In the year 1996, resulted in the formation of national campaigns for people right to information, like I told you, and this in turn related to the formation of RTI bill. So the right to information bill is prepared and it is sent to the government by the National Campaign Committee and other groups associated with it. They all received the support, full support of the Press Council of India, PCI. Okay, the PCI. In the year 1997, government refers the RTI draft to a committee headed under a expert, because they wanted an expert opinion on the right to information bill. So the expert's name was Mr. H.D. Shauri. He thereby, what he did is that he had to submit a report to the government based on the draft. So he submitted it, and after that, after 2 years later in 1999, a cabinet minister allows access to information in his ministry. It's not hid, it's his. Please pardon the typing error. And then what happened is that the order is reversed by the Prime Minister of India. So when a cabinet minister, he's a senior minister, it's a big minister, they have big post. They allowed access, one of them allowed access to information in this ministry, and that particular order was reversed by the Prime Minister. So you have to understand 1975 to 1999, almost 25 years, that is 24 years to be specific. This is the timeline of right to information concept. Moving on, let us take the next 4 years. Next 4 years resulted in the background check for the Right to Information Act. Because a lot of councils, a lot of committees, there was a parliamentary committee that is involved. A case was filed in the Supreme Court in the millennium, that is 2000. We say Y2K, right? 2000. So Millennium opened a case in the Supreme Court demanding the institutionalization of the RTI. So H.D. Shauri committee submitted its reports and suggestions. Okay, in the year 2001, that's the next year, the parliamentary committee gave its recommendations. In 2002, Supreme Court gives an ultimatum. That ultimatum in the form of a kind of a deadline. It tells the government, enough, please make sure you hurry up and form the RTI Act. So in that speedy moment, what happened is we got one particular act which is a total failure. It was called the Freedom of Information Act 2002. So for an act, it was passed in both the houses because there are 3 readings in the bill, that it became an act. RTI bill became an act called the Freedom of Information Act 2002. However, it was never notified in the Gazette. Public were never notified. It went to the president's desk and he gave his assent also. However, in 2003, it was never notified. So it was a failure. In the next upcoming year 2004, national elections were announced, and Congress, in their manifesto, they told they will include tougher RTI laws. Okay. So that was a boost to the movement of RTI. Then one of the most important councils was set up. It is called the National Advisory Council, NAC. This was set up under the leadership of Sonia Gandhi ji. Under the leadership of Mrs. Sonia Gandhi ji, the National Advisory Council was set up. And if you look at the timeline, how 2004 was crucial, because in June 2004, NAC was set up. In August, that is few months later, in 2 months, NCPRI sends a draft bill to the council, National Advisory Council. And then in December that same year, 2004, the RTI bill is introduced in the parliament and is referred to a committee for final approval. So January to April 2005 was very crucial, as the bill is considered by the parliamentary committee and also the council of ministers, and a revised bill, okay, a revised bill covering central and state governments is introduced. What happens next? In May 2005, the RTI bill is passed by both the houses. It is passed by both the houses. Right, dear friends? In June 2005, President gives his assent, right? And October 2005, the Act comes into force. Kindly remember, October 2005, the Right to Information Act comes into force. And from 2006 to 2009, two attempts have been made, abortive attempts by the government to amend the RTI Act. You should please note that. Dear friends, any doubts? Any doubts, dear friends? You can put it in the comment box as I am watching in my phone. All right. So I'm moving on. Now let us go to the state level hierarchy. So this is a hierarchical pattern. Please follow this. Please follow the hierarchical pattern. Any competitive exam you write, you should follow the hierarchy. Hierarchical means after 1997 comes 2000. After 2000 comes 2001. You cannot say 2001 comes first and then comes 2000. It doesn't work that way. Because when you're memorizing things, you would like to follow A, B, C, D. You don't memorize as C, D, B, A. Right? So there is a order to be memorized. There is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Not 9, 8, 6, 4, 3, 2. No. It doesn't work that way. It will affect your pattern. So you should follow a pattern. And Goa and Tamil Nadu were the first few states to introduce the RTI Act in their state laws. Respect to their state laws. So there were public information officers. In Tamil Nadu, what they set up was public information shops were set up. Distribution pamphlets were distributed. Okay, all these things happened. So Goa also played a crucial role regarding the development of the RTI state laws. So now let's move to Rajasthan. How Rajasthan played a key role. Rajasthan, the movement of RTI began in Rajasthan. Okay. So Rajasthan, Aruna Roy and Mazdoor Kisan Shakti Sangathan, all that MKSS played a crucial role in the Right to Information State Law Act to be passed. In Karnataka, the same year 2000, the Right to Information Act played a role. So in Karnataka, 12 categories of information are shared. There are 12 categories of information that are shared with the public. Hope you are following, dear friends. In Delhi, a capital, 2001. Maharashtra, which is the financial hub, 2002. So Delhi followed the lines of the Goa's Right to Information Act. Okay, Delhi took a lot into its consideration by following the Goa Right to Information Act, the state act. Assam and Madhya Pradesh followed suit in 2002 and 2003. So please remember this hierarchical pattern. Meanwhile, dear friends, I would like to just stress, please use my referral code for subscribing to Unacademy. My referral code is Cyril Thomas Jacob. I'll spell it out for you, dear friends. CYRIL THOMAS JACOB. Referral code, if you use it, you will get a 10% discount on Unacademy plus subscription. The reason I tell you to subscribe to Plus, dear friends, is that you will get a lot of benefits. Like live classes, okay? The benefits, please subscribe to my channel, use my referral code. Once again, I tell you the benefits of subscribing to Unacademy is that you'll be having weekly quizzes, you'll be having mega quizzes, all prepared and set by me. Then you will have access to all the top content by top educators. All the topics and syllabus will be covered. Right? You'll be having mega quizzes, which is 1 hour, and you will be having doubt clearing sessions. My doubt clearing sessions are 2 hours. On every fourth class, you'll be having doubt clearing sessions. So whatever doubts you have, you can clear it, either few doubts in the class then and there, or if you have more doubts pertaining to the subject, I teach law, you can clear it in the doubt clearing session. A lot of important case laws, a lot of important principles of laws, a lot of concepts, systems of administrations, international concept, international perspective, Indian perspective, all this will be highlighted in my class. A lot of real life examples also will be taken. So please use my referral code Cyril Thomas Jacob, right? My referral code is Cyril Thomas Jacob, CYRILTHOMAS JACOB. You'll get a 10% discount on your plan. I suggest you take the 6 months or 12 months plan, because NTA net, nothing happens overnight. Right? So moving on. Now let us look at the constitutional dimension or constitutional perspective. This is very important. I stick to the syllabus. So syllabus is king. You should know that, dear friends. So Article 19, Clause 1, Subclause A of the Indian Constitution. Freedom of speech and expression is guaranteed in this article. However, there is a limit. Yeah, your freedom ends at the tip of somebody else's nose, or your liberty ends at the tip of somebody else's nose. So you should not misuse the RTI platform that you have. In the case of SP Gupta versus Union of India, it was a landmark case where Justice V. Krishna Iyer, who was a eminent jurist, who was a legendary jurist, he observed that the right to express thought, one's thought is meaningless if not accompanied by the related right to secure all information on matters of public concern from relevant public authorities. So it is guaranteed by this judgment in the case of SP Gupta versus Union of India. The opinion should be accompanied by certain right to secure or seek all the information. So people should not be deprived of their particular respective right to know. It is a constitutional dimension as per Article 19, Clause 1, Subclause A. It will be a violation of Article 19, Subclause 1, Clause A if the right to know is not guaranteed. About every public act and regarding every transaction undertaken by public functionaries or public administrative authorities. So people have a right to know. Alright, regarding the public functionaries. So I have brought about a list of case laws. Now in these three case laws, you will find that how right to seek information is so important. So in Bennett, Coleman and Company versus Union of India, the court held that freedom of press, that is freedom of press is media related, right? The freedom of press means that the right of all citizens to speak, publish and express their perspectives. Now what do journalists do? What do media officials do, dear friends? They like to publish information. They like to take part in investigative journalism also. That is a trend that is coming up. Right, dear friends? So based on this, what happens is they need to know that how important their freedom of press is. And Supreme Court held in the case of Bennett, Coleman and Company versus Union of India. Okay, it was the company versus the Indian government, central government. So the Supreme Court held that every citizen in India has the right to speak, publish and express their perspective or opinion. Okay, it includes the right of all citizens to read and stay informed. So citizens have a right to be well informed. In Express newspaper versus Union of India, this is the first case that I highlighted. Let us move on to the second case. In Express newspaper versus Union of India, reported in the All India Reporter AIR in the year 1958 by Supreme Court. So this is another landmark case. In this, the Supreme Court observed that the basic purpose or objective of freedom of speech and expression, Article 19, the basic purpose of Article 19 was observed in this landmark case. So it held that the right to acquire or obtain information includes the right to access the source of information. So sources of information also should be properly accessed, and especially governmental bodies or governmental departments should have a public information officer at their disposal to disseminate information, to give out or distribute information. That is why when in Tamil Nadu, when they had the Right to Information Act passed in their state in 1997, they had public distribution of pamphlets by governmental offices. Okay, it was so advanced that time. Hope you are following, dear friends. Now let's move on to the third aspect. In Ozair Hussain versus Union of India, excuse me, in Ozair Hussain versus Union of India, the Delhi High Court held that it is the customer's right to know the ingredients of food products, cosmetics and drugs. Drugs means pharmaceuticals, medicines, not the other ganja. Okay. Something is wrong with my pen, so please pardon the scribbling, or else the fundamental right will be standing violated. So dear friends, as a customer, when you're going to a supermarket, okay, you will be going for some toothpaste. Now if the toothpaste is harmful for you, you have the right to know what are the ingredients of that cosmetic or toothpaste or medicine, right? That is your right to know. If they are not providing, the company is not providing you with that information, your fundamental right to know will stand violated, or it will be breached, or it will be infringed upon. Right, dear friends? Any doubts regarding this? So even in fruit products, right, there are expiry dates. You have a right to know when it expires. You have a right as a consumer, you have a right as a citizen to know the ingredients of certain food products. You do not want to have certain harmful products into you don't want to consume it. So are there any doubts? Please put it in the chat box. Let us move on. Now we took into consideration Article 19. Now let us take into consideration a further perspective in the constitutional dimension, which is Article 21. So With this, Article 21 provides that no person or no citizen in India shall be deprived of his basic fundamental right to life and liberty. So, right to life and liberty is guaranteed under Article 21 of the Indian Constitution. Right, dear friends? So, let us move on to the first case. In RP Limited versus Indian Express newspaper. So there is a media, because media, like I told you, NCPRI, the National Campaign for People's Right to Know, was given a boost by the particular Press Council of India, right? So in this particular case of RP Limited versus Indian Express newspaper, right, the Indian Express group, the Supreme Court held that people have a right to know because they have to take part in the development initiatives or programs of a democracy. So India is the largest democratic country in the world with the largest written constitution. So we have two things that are major. Okay, apart from population, apart from army, we are the largest democracy in the world. We have the largest written constitution in the world. A constitution that guarantees to each citizen in its preamble democratic, socialist, sovereign, socialistic, secular republic. Okay, we are a democratic, sovereign, socialistic, secular republic. So people have a right to know because they have to partake in that democratic events and developmental initiatives in a democracy. So Supreme Court held the judgment in that particular Indian Express case. Now second case pertaining to Article 21, dear friends. We are keeping a further perspective, right? So there is a body called People's Union for Civil Liberties, PUCL. You must have heard about it. Okay, versus Union of India. In this, the Supreme Court emphasized on participatory governance. You must have heard about self-governance, or you may have heard about self-governance in those kind of systems of administration. Now, participatory governance when people are actively participating. In Indian form of government, people indirectly participate in the election as they elect their representatives from their respective constituencies to the state legislative assemblies or to the central legislature, which is the Parliament of India. Now, Parliament has two houses, that is the Rajya Sabha and the Lok Sabha, the upper chamber or the upper house and the lower house. We got a parliamentary system from UK. Now, India and US, countries like India, USA are democratic countries. So citizens should be very well aware in order to participate in that elections also. So no information should be hidden from them unless it is in the interest of national security. Okay. So let us discuss another case law. In Ravi Kumar versus Bangalore University, the Supreme Court observed that the public authorities cannot deny, I repeat, cannot deny any document just on the ground of confidentiality. Okay. So if you want certain information and the government is denying you that information, it has to give you proper, the public information officer has to give you proper justification as to why that information is not shared with you. Okay. They cannot terminate or deny you any particular document just on the ground of confidentiality, telling that this is highly secret document, this is highly classified. They need to give a reason why it is classified. Then fine. Or you should know what is excluded, right? Hence, the right to information may be considered as a basic guaranteed right to Indian citizens. It's a fundamental guaranteed right. With this, hope it's clear, dear friends. Now moving on, let us move on to the government report findings. There is a white paper document, that is white paper documents are official documents. So based on that, there are certain findings based on which the functioning of RTI Act was brought about. So whether the RTI Act is successful or not, the government prepared a report in the early 2000s, okay, and it was found out in the previous decade. These were the findings. Awareness about RTI Act was minimal, that is, it is very less among the rural population. So the poor villagers had a lesser knowledge about the RTI Act 2005. So if ignorance is there, then it's a problem. So more programs, more campaigns should be set up. That is the solution. That is the recommendation from experts. Even I feel the same. More programs should be set up. Second, public information officer often harassed applicants in rural areas. How does harassment happen by the public information officers? I'll give you an example. Suppose I am a public information officer and you are seeking, you're a rural villager, you're from a person from the rural area, and you're coming to me with seeking some information, and I'll be keeping on telling you, come tomorrow. You'll come tomorrow, I'll again postpone it. So you are mentally, you are like, when will this happen? Physically, you're wasting your time and energy and coming. Mental, physical harassment. Hope you're following. This is wrong. So government authorities needed proper training. Lack of training results to inefficiency, ineffectiveness, and also inability to do the work. If the government authorities have to function in an effective, efficient, and productive manner, and if they want to respond efficiently to all the applications, then they have to be adequately trained. So because of the inadequate training, there's a huge backlog. Huge backlog means lot of pile of documents, lot of pile stock, lot of stock of documents. So between October 2005 to March 2008, there is an estimated 2 million RTA application. 2 million, dear friends, in Indian terms, it means 20 lakh applications were there. Okay. 20 lakh applications were there between October 2005 to March 2008. Span of 3 years, 3.5 years or 3 years. However, it was noticed by the government of India that only 4 lakh came from rural areas. So 16 lakh, that is 1.6 million, and 0.4 million only from rural area, 1.6 is from urban areas. So they had a feeling, the government had a feeling, it gave an impression that only educated people want to seek information. And illiterate or uneducated or lower areas, in rural areas also there is school, but education is yet to thrive there, yet to be fully, because they have a lot of obstacles. They have farms, there is today the government has launched a lot of schemes like Beti Bachao, Beti Padhao. In villages, women are not, girl child is not open to education. They have been stopped from getting educated. A lot of problems are there. There have been movies also. If you watch Swades, Shah Rukh Khan's movie Swades, you will be understanding the dilemma of girl child. So Information Commission is set up. The duty of the Information Commission is to ensure it acts as a redressal mechanism. Redressal mechanism means to settle any complaints or disputes. So this functions at 2 levels, state level and central level. Every government office has its own public information officer who is responsible to accept or reject the applications. Okay. They have to provide information within 30 days from the date of request. There are also assistant PIOs, that is assistant public information officers, which are posted in post offices, in cities and in towns. So what is the whole need? What is the need? There are 3 points I highlighted here. It helps in reducing the vacuum. Like I mentioned in the first slide, there is a gap. to solve the gap, to reduce the gap between the administration and the people, to ensure that friendly public information officers or accessible public information officers are there, we need a central information commission. Okay, to reduce chances of abuse of power or misuse of power. Point 2, then to make more people more aware of the administration. Okay, so what can be excluded is the national security, in the interest of national security and all that. So dear friends, hope you have followed till here, right? So exclusions under the act, the final slide. Any restrictions as per the Official Secrets Act 1923, it will not be given. No information dealing with the security of India. India's security is prime, national security, threatening that no information will be given that endangers the national security, personal security like the defense, CID, BSI, Border Security of India, Police Force will be given. If any malfunction or corruption or malpractice exists in the department, then that is an exception. However, there are restrictions that should be followed, and this also should be considered. Right, dear friends? Hope you followed. We discussed Open Government and Right to Information Act. We considered constitutional dimensions. Please use my referral code Cyril Jacob. You will get a 10% discount. Subscribe for the 6-month or 12-month plan, and you will have a more interactive session on